I'm Mari Margil with the Center for Democratic and Environmental Rights. Within the Rights of Nature movement, which, since 2006, we've had the first Rights of Nature law. So it's been about 15 years since this movement has moved from theory into practice. That is actually moving legal rights of the natural world into binding law. And with that has, when you're creating a new set of rights for a new entity, in this case, a living entity that has rights, you're going to face all sorts of questions about how do you do this? And like most things, we've tried to fit ourselves into existing legal frameworks. And in the case of rights of nature, it's about creating a whole new set of rights for the natural world. But that's not the easiest thing to do. And human structures of law weren't intended to protect nature with legal rights. And so it's been, it hasn't exactly been the smoothest road. And so what we've seen are a couple of different things occur. Number one, we've worked in places like Ecuador where they have the rights of nature in the Constitution and recognize certain legal rights, constitutional rights, the highest level of protection that they have. A right to evolve, a right to restoration, a right to even exist. Those are monumental shifts in terms of how nature is treated under the law. But you've also had other places that have recognized the certain rights of nature, but done it within what's called the legal personhood construct or framework. Essentially, what the legal world has done is broken the world into two. You're either a legal person that means that you can hold both rights and responsibilities, or you're not a legal person in which you don't have legal rights and you're not considered to be a rights holder. And that means that you're not even really seen by the law. You're not seen by courts. You don't have that level of protection. So you're either a legal person or you're not. That's how the world is broken up into two. And that becomes a problem when you're talking about nature. So nature now is moving onto the scene. It's not been considered a legal person. It's not been considered a rights holder, a bearer of legal rights. But now that it's moving in that direction in Ecuador and other places, the question is, well, is it a legal person? Well, what does that mean? And that raises all sorts of questions because this concept of legal personhood, and it dates back eons, essentially is this idea that to be considered a legal person, you have both rights and responsibilities or duties, obligations, which is proving itself to be a poor fit for nature. Because when you think about this idea of how can nature have obligations, legal obligations that we humans can understand or hold it accountable to, that's not a terrific fit for nature. And so nature has found itself in this sort of awkward place where it's trying to fit into existing human legal frameworks, like existing human legal system, but it's not a terrific fit. And so it's been a challenge to determine, okay, well, how do we do this in a way that makes sense for nature, protects the rights that nature now has, and do it in a way that allows for it to be properly implemented and enforced. In certain places, like in India and New Zealand, you've had court decisions and you've had national legislation that have recognized legal rights of particular ecosystems. So, for instance, in India, you have the Ganges River and the Yamuna River and their tributaries. The High Court of in the northern part of India recognized that they are legal persons, but it did it in a way that says that, and I have the language right here, so I'll read it to you, that the rivers Ganga and Yamuna are declared as legal persons having the status of a legal person with all corresponding rights, duties, and liabilities of a living person. So this real world example became all too real when it was appealed to the India Supreme Court to try to overturn the decision that the Ganges possesses legal rights. And what the appeal argument against this ruling is, well, what happens if the river should flood and kill a human being? How do we hold the Ganges River accountable for essentially a homicide against a human being? Which is an absurd question because, of course, you can't hold the river liable for that. You don't want to hold a river liable for that or any other ecosystem or species for behaving in its natural way, in its natural function. But it was a really important lesson in the kinds of absurd arguments that are going to be used to try to overturn or stand in the way of recognizing rights of nature. But it also is, it's an obvious argument to make because the legal personhood framework says that a legal person possesses rights and responsibilities. So of course they're going to put forward this argument. But it also then says maybe legal personhood isn't a terrific fit for nature. Legal personhood was never written to protect nature. It was never intended to protect nature. And it's not a good fit. It sort of muddies the waters, if you will. And so we think that we need to actually essentially move beyond personhood when it comes to nature. Because what you want is, if you're going to expand the body of legal rights to include this living entity that is the natural world, you want to make sure that it works. That is, that it can be properly implemented and enforced. And we think that we really need to create a legal system that matches that need. I call it legal naturehood. Essentially, a way to ensure that when nature is recognized as possessing legal rights, like in Ecuador's constitution, Uganda's National Environmental Act, local communities in the United States, that you have a way for legal systems and courts to be able to properly consider those, interpret those, enforce, defend those, which means that you want to make sure that you're meeting the needs and interests of nature that is now a legal rights holder. Because if they're not able to properly enforce and defend and implement those rights, it becomes meaningless, which is obviously not the intent. So we have to create a new legal system to hold this new rights holder of nature so that we can make sure that those legal rights, that the promise of those rights are being properly realized, and the protection of nature is far higher than what it is under conventional environmental laws. We haven't used legal naturehood yet. We're sort of putting it into that and starting to think about what does that look like. But I can tell you that in some of the lawmaking processes that we've been involved in, what we have done is essentially establish certain provisions within draft laws to try to cut off some of the harshest edges of legal personhood as it applies to nature. That is to say, provisions that essentially say that recognizing nature as possessing legal rights does not mean that nature suddenly has duties or obligations or responsibilities. We don't want to give space to this notion that nature has obligations that we humans are going to determine. Nature performs natural functions. The protection of those natural functions is really, really quite important. It's a way that that nature is healthy and robust and resilient if it's actually able to perform those natural functions that a healthy ecosystem otherwise would. And so trying to using this existing framework that we already have, because we're working within today's legal system, recognizing rights of nature, but making sure that it's not being held accountable for its actions in a way that simply don't make any sense under our existing legal framework. I think what's important to understand is that this movement to establish, recognize legal rights of nature, which is really growing in countries around the world, advocates are working within the legal personhood framework because it's what's available. It's a means to the end of having nature recognized as bearing rights. But I think we're going to need to move beyond it to make a more robust system that is written and intended to protect the rights that nature is being recognized as having. So I think that's where we are. We're working with what we have, but we need to actually move beyond it to ensure that the legal rights of nature are being properly understood and interpreted and implemented and enforced. And so I think it's important to understand where we are, but where we also need to go. And so in terms of, sort of really important developments within the rights of nature global movement, in November 2020, in the state of Florida, a community called Orange County, on election day, the people there voted overwhelmingly to recognize that certain rivers, the Waikiki River and other waterways within that county, and this is where Orlando is, where Walt Disney World is, so many people around the world have probably been in Orange County, that they recognize that those rivers and waterways within the county possess legal rights. And it's important for a number of reasons. Number one, it's the first rights of nature law in the state of Florida. It's also the largest jurisdiction within the United States with nearly 1.5 million people. It's the largest jurisdiction in this country that has a rights of nature law in place. And importantly, in the spring 2021, where we're speaking now, you have a lawsuit being brought against the state of Florida and against a developer that wants to do a housing and commercial development within Orange County that would fill and therefore destroy wetlands within the community as well as streams, and therefore violate the rights of the waterways within the community that have now been recognized in law. So a legal challenge has been filed to stop that development from going forward. And it's very importantly within the United States, the first enforcement case that's being brought forward under a rights of nature law. What that means in practice is that plaintiffs, that is waterways, wetlands, rivers, streams, are bringing the case forward. They are the ones that are the parties in the case, saying that we are bringing this case to defend our rights, even our most basic right to exist. And that's the first time that's happened in the United States. So it's a really important development. And it's just happening now in the spring of 2021 when we're talking. And so we'll see how it plays out over the next months, years, whatever it might be. But what's great about it is, we're seeing this enforcement happen. It's just what you want to have happen when you put a rights of nature law into place, that you can stop things that will violate the rights of nature, and a very, very clear example that this development would be. So there's been, since Ecuador's constitutional framework constitutionalizing the rights of nature was put into place in 2008, there have been a number of cases that have gone through lower courts and up to the Constitutional Court. And what's really quite interesting is that over the past year or so, Ecuador's Constitutional Court has selected a handful of cases to review that involve the rights of nature. Essentially, what the court has said is we need to establish, really build out what does it mean that nature possesses rights. Already, the court has affirmed that nature possesses constitutional rights. They've also indicated that those rights are interdependent with other constitutional rights. So within the Constitution in Ecuador, there's a human right to a healthy environment, a human right to water that have been recognized as constitutional rights of human beings. And then, of course, nature has been recognized as possessing constitutional rights. And the court has said that the rights of nature radiate out and are dependent upon other rights, which means that the human right to a healthy environment is dependent on the right of the environment itself being protected, and vice versa. Those are huge steps forward in the jurisprudence regarding the rights of nature. And now we have the Constitutional Court selecting cases there that are going to further define what the rights of nature really means. How do we reach that higher level of protection, that higher standard of protection that establishing the rights of nature in the Constitution is intended for? So I think we're going to be seeing some really interesting developments come out of the Constitutional Court in the next few months and years. I do a lot of work both in the United States and elsewhere, but we have some really interesting developments. So for instance, with the Menominee Indian tribe in the Midwest of the United States, they passed a resolution in 2020 to recognize rights of the Menominee River. And now they're moving forward to look at their tribal constitution to see if they want to amend that with the rights of nature. So that's a really interesting and important development. And then in other places, for instance, in Switzerland, where we've been working with activists there over the past year, they have just worked with parliamentarians to introduce what they call a parliamentary initiative, in which they're introducing the idea of amending the Swiss constitution to enshrine the rights of nature. And that just occurred in March 2021. So it's a really interesting and important development. We don't have rights of nature yet within anywhere in Europe established into law. So this is a really big step forward toward that end.